All right, folks, welcome. Welcome in, folks. Let's begin. Welcome all to NYU School of Law. We are delighted to be welcoming you to the forum this afternoon. The Latham & Watkins Forum today will focus, as you know, on the ESG backlash, one of the most pressing issues in American public policy today. And we are very fortunate to be joined by an esteemed group of panelists who we are going to put on the hot seat in the fine tradition of our NYU Forum and press them to answer hard questions. First, my own, but then from all of you. Folks have been kind enough to send in questions for our panelist consideration. I'll ask some of those, and if you make me, I'll even call on you, being a law professor. Folks, I'm Rob Jackson. I'm a professor here at NYU Law. I'll be moderating the forum. Before I was here at NYU, I was a commissioner on the Securities and Exchange Commission, and before that, a Treasury official in the Obama administration, where I worked on, among other things, the Dodd-Frank Act. Sorry. For those of you who are not familiar with our panelists, let me introduce you and give you a sense of the extraordinary insights you're going to hear today. First of all, to my immediate right, my colleague and friend, Allison Herron-Lee, formerly the acting chair and with me briefly a commissioner on the Securities and Exchange Commission. Now my co-teacher here at NYU Law, where we have the very great pleasure of teaching together in the Jacobson program, leadership program on law and business. Allison, welcome. I'm also joined by my co-author, Shiva Rajapal, from the Columbia Business School, where he has for years focused on the accounting scholarship that has made him a world-renowned scholar in accounting, but more recently has weighed in on a range of public policy issues, including ESG-related questions, and will benefit a great deal from his expertise. Finally, on my far right, we're joined by Betty Huber, the NYU Law graduate, who is now at Latham & Watkins, and host of the forum, and I should say, joined by her former NYU Law professor, David Katz, who is sitting in the front row ready to ask hard questions like he did when she was here in law school. Welcome back to NYU. And finally, last but not at all least, my former colleague, the director of the Division of Investment Management, former director of the Division of Investment Management, Dahlia Blass, who is now the head of external affairs at BlackRock, putting her at the eye of the storm in many of these questions. Dahlia is joining us by Zoom. Welcome, Dahlia. And as we agreed, I'll come to you with the first question. But first, let me offer a little bit of background. For those of you who haven't caught up on the news yet this morning, I really couldn't have asked for a better context and introduction than the announcement this morning that we have a new announced candidate for President of the United States. It is Vivek Ramaswamy, who's become famous for his woke Inc. pushback on the liberal agenda plaguing corporate America. And he has decided that what we need is another candidate for president. He has railed against woke investing, according to Bloomberg, who announced his candidacy for the presidency this morning, based on environmental, social, and governance principles. And if that wasn't enough, there's an article in the Financial Times this morning pointing out that Vanguard CEO Tim Buckley is playing defense because Vanguard has dropped out of the Net Zero Asset Managers Initiative. He told the Financial Times that Vanguard's voice was being drowned out or confused on ESG issues, and therefore they have abandoned the group working on the Net Zero Asset Managers Initiative. So that brings me to my very first question for you, Dahlia Blass. BlackRock has been a leader on questions related to ESG investing, and particularly issues of climate-related investing questions. BlackRock has for years, through the annual letters of your boss, Larry Fink, made clear to issuers that there is an expectation that they will disclose to large investors like you the climate-related detail that you need to make investment decisions. On the other hand, as you have been leaders on those questions, Dahlia, some have been skeptical of BlackRock's role in this important debate. In fact, I think you've been hailed down to the great state of Texas, where in Austin, Texas legislators wanted to know why you were deploying their assets in pursuit of a woke agenda. So Dahlia, let me ask you, are you deploying assets in pursuit of a woke agenda? And if so, why?
Thank you so much. And thank you for inviting me to be part of this forum, and to Latham and Watkins as well. And first, I will apologize for not being with you all in person. After 3 years of escaping COVID, it finally found me on this very week. So I'm quarantining at home. So first, I think it's important to level set the conversation. So 4 things. One is we're having a conversation without even speaking the same language. And that is a huge problem. There is a material and fundamental lack of understanding about sustainable investing and what it means to manage sustainable risks and opportunities, from different stakeholders when it comes to the capital markets. Why? Because of how the term ESG is used and what it means to different people. So it's really important for us to better explain the drivers behind sustainable investing, what it means from a capital markets perspective. The second point is there is a lack of understanding about how sustainability is integrated into the investment process. For example, there is a difference between a fund that has an impact or a sustainability objective versus a fund that screens certain investments versus a fund that incorporates financially material ESG risks along other risks and opportunities. And when it comes to like geopolitical or market or credit, when it comes to the investment process. The third point is that there is a lack of understanding about asset management, period. And that's a problem. Asset managers are fiduciaries to other people's money. And Rob and Allison, you were right there in the commission when we adopted the federal interpretation of what is a fiduciary and what a fiduciary can and cannot do. Fiduciary asset managers provide the advice, the data, the analytics, the products, but it's the clients that give the mandate. The client is the one that chooses, and it's really important to abide by the mandate and by the client choice. If a client wants to invest in a transition finance type portfolio, if it wants its portfolio to align with a net zero initiative, that is the client's mandate or choice. On the other hand, if a client does not want to incorporate climate considerations into its portfolio, again, that is the client's mandate. And the duty of a fiduciary asset manager is to provide the best risk-adjusted returns within that mandate. So it's 2 very fundamental cornerstones of asset management that are sort of not being discussed and not out there: client choice and the asset manager's fiduciary obligation to abide by that choice. And then the 4th point is voting. And as you know, Rob, that was a hot topic during my hearing down in Marshall, Texas. Asset managers, unlike other investors, and Rob, I know you know this point quite well, are very transparent by law about how they vote. They're required to. But the how and the when and all the good stuff. And this has resulted in both sides looking at the votes, parsing through our votes, and in some cases saying, asset managers have gone too far, in other cases saying asset managers have not gone far enough. But this is why it's really important for us to be talking about how to democratize voting, to bring more voices to the table, because this is obviously a really important issue for many investors and market participants. And at BlackRock, we are very proud of having pioneered voting choice, just as we are very proud about having pioneered a sustainability platform for the clients who are choosing their mandate, their choice to invest in the transition finance or in sustainability products.
Well, Dalia, thank you for that. That's a wonderful frame for the conversation. Let me start just with a little bit of pushback. It wouldn't be an NYU forum if I didn't push back a little bit. How much choice is there really, Dalia, for those customers who are investing in BlackRock? After all, many of those individual investors you're talking about have limited 401k plan choices. Their employer chooses who will manage that 401k and chooses the limited menu that they face. Is this as free a market as you're suggesting, Dalia, or are people being nudged into and out of pro-ESG or anti-ESG investing for that matter?
That's a great point that you raised, Rob. The 401k plans. What you're talking about here is institutional clients. These are plans that are managed actually by fiduciaries themselves, and they are looking at the marketplace. This is a very diverse marketplace with a lot of players, a lot of products, a lot of choice. And choice does exist. There's a lot of choice in the market, and we provide choice. We provide sustainable products. We provide traditional products. We provide the entire value chain of products to meet the different needs of the different clients in the market, because we recognize that clients have different mandates and they want to invest their returns in their investments in different ways. Our job is to provide them the best risk-adjusted returns that we can within their choice, their mandate. There is choice in the market.
All right, well, we'll come back to that, but first let me turn to you, Betty Huber, because at Latham & Watkins, I know you're advising, gosh, more than 1,000 public company clients, and you're getting the question that Dahlia and other institutions are asking in all kinds of different ways. In fact, I think recently a bank got a letter from the state of Texas asking why that bank is pursuing a net zero target. I think that some US senators might be asking lawyers here in New York to preserve their documents because they're having the temerity to advise clients about subjects like ESG. So Betty, how are you navigating that as you're trying to advise clients about the right thing to do in response to the questions that folks like Dahlia is asking?
Yeah, thanks so much, Rob, for that great, very broad question. So I graduated from NYU about 26 years ago, and back then in 1996, as Professor Katz can tell you, ESG was not a thing. And when I started as a basic corporate lawyer, just advising businesses on how to conduct their businesses and navigating laws, that's all I've done for the past 25 years. In the past 5, ESG has really come to the top. And sitting here in New York City as a New York lawyer, most of my clients are financial institutions, are asset managers, are investors. I have a couple who wanted to speak with me before this, and I said, no, I'm tied up from 1:10 to 2:30. And what they wanted to talk about was about exclusionary screens, how they can get the share of the wallet from ESG investors. So the fact that all of this is happening and all of this anti-ESG agenda, that's not what's happening at my desk. That's not what's happening 24 hours a day, 7 days a week for me. In fact, they're asking, well, how do we navigate all of this so we can figure out who our limited partners are, if we've got New York State, investing in us, which has one agenda, Maryland similarly, but then you've got Texas and Oklahoma and Kentucky doing something else. Tell us how we can set up our funds so that we can actually get their money because they're basically opposing each other. As a global law firm, we also focus on the EU regulations. And if you take a look at the SFDR, the Sustainable Finance Disclosure Regulation, that's completely opposite. It's basically demanding products to disclose what their ESG strategies are. And if you don't do that, you don't get share of the wallet. When I talk to my European colleagues, they're shocked to hear that this is happening. To them, they're thinking, ESG disclosures, ESG strategies, this actually leads to long-term value. So everything that Dahlia said resonates very, very clearly with me. Finally, maybe, Rob, just because you did mention the letters that I personally got on behalf of my law firm from some politicians, I had an emotional reaction to it for sure. I was alone in a hotel room when I got it at midnight in my email. So at first I thought it was spam, and then I looked carefully and realized it wasn't spam at all, and it was actually from 5 senators. So I sent it, internally to my Office of General Counsel. And I would say that, resoundingly, we decided we can't do our jobs. Our jobs are to advise our clients to navigate laws. It's not about price fixing. It's not about any of this. It's not about creating an anti-competitive market. It's about trying to figure out how we can actually satisfy the investors who invest in 401ks, et cetera. So I have much more to say, but I'll leave it there for now.
Well, thanks, and welcome back again to NYU, Betty. Allison, I think Betty's given us a great introduction to turn to you, because she pointed out, among other things, that a lot of the ESG backlash we're seeing now comes in part from stuff you did. Because as acting chair of the SEC, Allison Lee prepared and then eventually the SEC proposed a wide-ranging set of climate-related disclosures that have been the subject of some of the political debate that Betty was just mentioning. And I have to ask, Allison, as you sit here now, back in law teaching here at NYU, are you surprised by the degree of backlash that all of this ESG-related transparency has produced? And if you could go back a year ago and do it differently, would you?
Well, those are two different, that's a compound question, counsel. But the answer is I would not do it differently, other than potentially to try to think a little more strategically around. I'll say that when I first came in, it was very clear to me that there was a massive amount of demand in the investor community for this information, and that risk was not being priced appropriately, and capital is being misapplied. So I knew we had to do something. I knew that a shift needed to occur, and that's why instead of just asking the staff to come up with a proposal, and this is more connected directly to climate, I put out a request for information and said to the public at large, weigh in advance of our proposal and help us craft something. I guess if I could do something differently, perhaps I would have reached out directly to some of the folks who are more upset about this right now to try to understand their vantage point in advance, but we have a record on that. We have lots of information on that. So I don't think I would have done anything differently, because the job of the SEC is to respond to investor demand, to have markets run well, to have them run fairly, efficiently, orderly. And in my view, there had been years of demand built up here. There had been an entire voluntary regime had built up based on this conversation that was happening between investors and the IR departments in these public corporations and the like, and that regime was creating problems because, in fact, capital was not being applied or allocated in the way that investors want. So I think we did the right thing by trying to get in and resolve some of the things that only a regulator can resolve, meaning things like consistency, standardization, reliability, enforcement, that type of thing. Am I surprised? I'm a little surprised, but at the same time, I think a fair amount of it, this is my own personal view, is political theater, because we do see that, in fact, even in these states where they have put some of the most kind of aggressive anti-ESG laws in place, those asset managers are still managing large amounts of the state pension funds. And then I have to throw in one really interesting fact that I just read, and I'm sure some of you have seen it, where in Kentucky, where they had one of these anti-ESG laws on the books, the Kentucky pension plan there actually came back and said it would violate our fiduciary duties to comply with this law. Which I thought was quite revealing and kind of turned the argument on its head, which is this notion that what's being done, the anti-ESG sort of backlash, is a focus on the notion that investors and others are focused on non-financial type metrics and data. I don't think that holds up, and I think when real fiduciaries look at this, like folks at BlackRock and like folks at Kentucky Pension Plan Fund, they determine that, in fact, these are real risks and opportunities that do connect to long-term value.
Now, of course, that goes back to a point that Dahlia mentioned earlier. She emphasized her role and BlackRock's role as a fiduciary and argued that constrains or places meaningful legal limits on the freedom they have to depart from a client mandate. Allison, I want to push back on something you said. Because you said, look, at the SEC, we're just responding to investor demand. And my question is, which investors? Because one of the critiques that's been leveled at the SEC's proposal, as you know, is that it's a demand that comes from the BlackRocks, from the Vanguards, or until today, I guess, from the Fidelities, but not from the ordinary mom and pop investors whose money is being used to pursue this agenda. So let me ask you, when you thought about proposing a climate rule and thought, well, I'm responding to investor demand from whom?
So first of all, the answer is absolutely from institutional investors, but that is generally how the mom and pop investors that you refer to access the markets. It's through those institutions. So they represent their interests in many ways. We don't often hear on a sort of individual by individual basis from retail investors. We do sometimes, and we did, in fact, in this case, and we have a pretty good record, and by we I mean the SEC, has a pretty good record of input from individuals that they want this information. But nevertheless, when the SEC is looking at markets writ large, it has to look at and consider the biggest investors in that space. Those are the ones doing the analysis, especially the fiduciaries. And I think the retail investors, for the most part, enter through that door as well. So I do think it captures both.
Makes sense. And Shiva, now let me turn to you and ask you, as an academic, watching both companies and investors respond to Dahlia's interest in and demand for, and she would say in service of investors, ESG, climate, and other related information, watching companies respond to it. How real are these, is this information? How important is it to asset pricing? And tell me a little bit about the accounting perspective that you take on some of these disclosure-related questions.
So you left the hardest question for me. So how real are these? So the way I think about this is, 4 buckets broadly. So what might ESG consist of? Let's say customers, employees, governance, and maybe the planet. And if you step back and think about why do we even need to talk about ESG investing, I think it's partly because, in my mind, the FASB hasn't done as good a job as it could have on the intangibles question. So a lot of this is just demand for intangibles is one way to frame the conversation. We need to know about customers. How can anybody have a problem linking customers to future cash flows, right? That's like self-evident. Employees, by and large, I think most people would agree, if you treat employees well, the culture is good, you can link it to future cash flows. Governance, in my mind, is a bit of an asymmetric conversation. People don't complain about governance when stock prices are going up 15, 20% per annum. And of course, suddenly they start worrying about governance when things are not going so well. Look at Tesla and Elon Musk. The planet part is complicated, the externalities. Why? Because in general, again, if you want to frame this as an accounting issue, our income statements, by and large, set the cost of natural capital to 0. I don't know how to price natural capital, but it is not 0. So that's issue number 1. Issue number 2, in general, our income statements and balance sheets also don't do such a good job measuring and thinking about externalities, both positive and negative externalities. Now, what are positive externalities? R&D. You pay, $100 for Microsoft Office, it probably adds much more to your productivity than $100 that you pay. That's the contribution of Microsoft to society. We should not forget that. On the flip side, of course, you have the usual problems, right? Unrecycled plastic bottles and whatever. So linking that to cash flows is messy simply because we need some kind of regulation or a carbon tax or something that will make companies internalize the externality. Otherwise, how do I show you a link to cash flows? So if you ask me, is all this priced? That's the framework I think about. There are some low-hanging fruit, customers, employees, to some extent governance. Externalities, hard to find evidence linking that to cash flows and stock prices. Not because it shouldn't exist, because we haven't figured out a way to get companies to internalize those externalities.
Now, Shiva, the perspective you've taken on, and just to unpack what Shiva said a little bit, he points out that the Financial Accounting Standards Board here in the United States hasn't done a tremendous amount of updating of their rules relating to things like intangible assets. And we should disclose, Shiva, that you and I are co-authors of a petition now before the SEC to make some rules requiring more detailed disclosure in that area. But, Shiva, I'd be remiss as a law professor not to say, is this really not priced? Is there a massive financial markets opportunity to better price ESG-related stuff? Because if so, we should leave here and go trade some stocks. I think I'd be remiss here at NYU not to push you on this issue, on this possibility that there's this massive market opportunity, when in fact we know financial markets are pretty efficient, Shiva. What say you?
They're not clairvoyant, right? So here's here's a little bit of pushback. Just if you think about what we teach in a high school economics textbook, what do you guys learn? Assuming some of you have taken some economics, right? So there's demand and there's supply. So if you're thinking about, say, an increase in sales for a company, I want to know how many units, what was the impact of price change and currency, right? If you look at the cost structure, how much of this cost is fixed versus variable, right? Again, go back to how value is created. It's some combination of materials, labor, capacity, and managerial talent. I take all these basic frameworks to a modern day income statement, I can't get answers to any of these questions, literally. We have a 6-line income statement with gazillion footnotes that by and large don't tell you any of these things that we teach. At least, my daughter just took the econ AP. This is refreshing for me. Wow, none of this. And how do I know? How many units does Microsoft sell? Was it price? Was it currency? What are Microsoft's fixed costs? How much labor? How much capacity? Nothing. So unless you say that, folks are very great at kind of figuring all this out and pricing that, and well, maybe. I don't know. I can't do it. I spent 12 weeks in my class trying to figure this out. The other issue, the passive investing issue, is also a concern. I've written a piece saying who reads a 10K anymore, sadly, as an accounting professor. A lot of money is run passively. So the incentive to actually do the hard work in terms of fundamental analysis and so on, and that extends to the ESG world as well, it's not obvious. There are incentives to do that. So if stuff gets into the index, prices go up. In fact, the trade, Rob, if you want to make money, guess which company gets into the S&P and guess which will get kicked out. Long the former, short the latter, you'll make money forever.
Now, that's not investing advice. Now, I want to turn to the questions from our audience, and welcome to the students. We have an overflow crowd. Please make yourselves comfortable. And we've got questions from our students and graduates that I'll turn to in a moment. But first, Dalia, I want to turn to you and ask whether that's BlackRock's view. Does BlackRock share Shiva's view that there's a market opportunity here, that assets are mispriced, and that providing more in the way of ESG disclosure will help us price them better? Is that the house view of BlackRock these days?
So if you step back, actually, Shiva, what you said is fundamentally ESG integration, which unfortunately the SEC, when it did the fund proposal, thought it's a fund type. It's not. It's exactly what you're talking about, which is looking at the unpriced risks and opportunities from environmental, social, or governance factors when you're looking at companies or sectors and taking advantage of that. And you're right, some of this stuff is, you're not going to open up your financial statements and get this information. I frankly question whether financial statements can be amended in any way, shape, or form to capture this universe. But that said, ESG data, analytics, information, metrics increasingly are on the market. And institutional investors like BlackRock, we look at that data, we pull that data together, we have in our Aladdin system, and that is how we look at ESG integration. So that is a part of the investment process, Rob, that institutional asset managers use.
Just to be clear, the name of that system is Aladdin?
Well, Aladdin is BlackRock's risk management system.
Like the genie?
Actually, Aladdin it's an acronym that stands for something really, really long. And please don't test me here, like, Socratic style, and ask me what it is exactly, because I will not get it right. But it's a risk management system. It manages, it looks at risks across the entire portfolio. And among that is, environmental, social, or governance risks, sustainability, climate risks. It's all part of that, of what we do. It's actually the ethos behind BlackRock's that started BlackRock. It's part of the BlackRock DNA is risk management, which is why we look at climate risk, just as we look at all other types of risks that can move asset prices in the market.
Makes sense. Now, Betty, I want to turn back to you because you shared a great deal about your journey since your time studying law here at NYU with David Katz and others. And really receiving that letter must have been an extraordinary thing. Hearing from United States senators about their concerns about your work in this area. And a question we got from several students is these state laws that restrict or otherwise purport to restrict the kind of investing that intermediaries like BlackRock can do, the kinds of communications that you can have with clients. How do we grapple with those? How should we think about in fact, more than 20 state legislatures have introduced laws based on a model of the kind that you were describing, Betty. How should we think about that as lawyers and citizens? And how can you contend with that as someone who's trying to, as you say, do your job and give your clients the best advice?
Yeah, I've asked myself that question for the past 2 years since we started seeing these sort of so-called fair access laws. And I was trying to, in my mind, organize them and bucket them to say, okay, if we can organize them instead of talking about them in a mass, we can then kind of tackle them one by one. And maybe two overriding alleged concerns about ESG. One is that maybe, and I'm not subscribing to this view, I'm just presenting it kind of like you've been pushing back a little bit. So one way that you could look at it is to say that ESG is anti-democratic. So you can hear a lot of people saying that ESG and all of this is, represents a view of certain elite people and not, the average Joe. You've kind of said that. So that's one way of looking at it, which I don't think is at all the case. I agree with everything that Allison and Dahlia said, but that's the way that, I guess certain states are looking at it. And the other one is that ESG is anti-competitive. And I'm almost taking over your job, I'm sorry, Rob, but the way to think about that is to say, oh, is ESG investing, does that lead to higher costs to investors? And I think that's thrown around these types of, this theater.
And Betty, you're right, we should unpack that. I think you're right. So there's two separate points Betty made there, and I think both of them have been made by those who are skeptical of this. The first is that disclosure of all this has to be paid for by somebody. And it's paid for by ordinary retail investors who would not on their own want the firms to spend their money this way. And I think that's a concern that could be taken seriously. The second concern is a concern about competition, that agreement across industries to provide this kind of disclosure will result in, or to choose more green or other kinds of methods of production, will cause prices to rise, which will bother those of us who are fortunate enough to be in this room a lot less than millions of average Americans who are not in a personal financial position to handle that kind of price increase. So Betty, what do we say in response to those concerns?
What I can offer as a practitioner is what I see in real life. And so, yeah, that's one way to look at it, but is it money well spent? And we're seeing that a lot of the ESG investors are long-term investors. And if it leads to long-term value, okay, maybe you're spending a little more in the upfront, but at the end it pays off. So it's the return on investment. I'm not, an accountant or a professor, so I can't give you the statistics on that. But what I can tell you is that I'm consistently hearing that from my bank clients who actually set up their own internal ESG ratings based on, in part, disclosure, but also in part in their interactions with different companies and different market participants. And then they decide who is, ESG worthy and where money should go. I mean, there's this whole new cottage industry within investment banks. Probably before, when you used to be an investment bank, this didn't exist. But there are these ESG solutions businesses within investment banks right now that's their job. They're trying to figure out how to match money between investors and companies, green money to green companies. So people want it.
You're right. I mean, I should say I was an investment banker in the 90s. I was at a firm called Bear Stearns. Not my fault. But I want to take what you've said and turn to Allison and ask her, Allison, these are real objections. Real objections that ordinary investors, many of them passive, are going to pay for this disclosure. And that the disclosure is occasioned not by market demand, but by regulatory fiat. And what's worse, that regulatory fiat coming from the SEC is going to nudge firms toward a set of dynamics that will cause prices to rise, and consumers are going to have to pay those prices. And I think it's incumbent upon us, if we want to be serious about this ESG backlash, to see that that's part of where it's coming from. And I'm curious what you would say to folks who take that view.
Well, I would start with this. All disclosures that are relevant and necessary and material in markets have to be paid for, period, full stop. So there's nothing unique about ESG in that regard. The question is whether it's warranted. And the question is whether, in fact, what's going on here is that investors on their own have identified an entire set of risks and opportunities that sit outside the financial statements, just as Shiva was noting, which is absolutely correct, that need to be brought into the analysis. So I don't take it lightly that it's going to cost companies. We always at the SEC, or they always, have to weigh those costs against the benefits. Here, I think we have enough history of investor demand for this information and enough history of companies understanding how valuable it is to their constituencies to understand that, in fact, we have a hole. We have a gap here that needs to be filled. Should we look for the most expedient way to do it? Yes, we should. Should we be aware of? Should we potentially scale the disclosures in a way that makes sense? Yes, we should. But I can't subscribe to the idea that simply because it's going to cost to disclose, that means we don't do it. We have to analyze it on a case-by-case basis. And here, I think these risks and opportunities have long been ignored and need to be addressed.
Now, Betty's point that many of her bank clients are building internal models just along these lines certainly provides support for the notion that it's investment meaningful. But Betty, here's another possibility. I'm curious about your reaction to this. Maybe what's happening is not that climate disclosure or social or governance-related matters are actually relevant to the future cash flows of the firm, as Shiva put it, but instead they're proxies for something that is. Instead, a board that's thinking about this is probably good at other stuff, like running a business. And a board that's not is probably not. It wouldn't be the first time, by the way, that governance and other measures were proxies for something hard to observe about what goes on inside a boardroom. Is that possible, Betty? And if that's right, then should we have an SEC disclosure rule that forces that information forward? Is private ordering a better solution? What do you think?
Again, a compound question. Private ordering, I think Allison said it before, that all of these different frameworks, and I was on the advisory council to SASB, one of the premier voluntary frameworks. Yeah, I think it caused a little bit of trouble, and it would be better if a regulator were to do it as opposed to various different working groups that came together ad hoc. Some were better than others, and so I don't know if private ordering is better than regulation. In terms of the proxy, I think that's an excellent point, actually, and because this is really, ultimately about, in some ways, governance. I'll answer it in a different way, an interesting development that maybe some of you haven't heard yet, but in terms of the ESG backlash, I've seen now a demand letter, a books and records demand letter against a company alleging that the board may not have discharge its fiduciary duties with respect to climate and environmental matters. I've been waiting for that for a while now. We've seen it with the ice cream case, with Listeria and Bluebell ice cream. We saw it with Boeing and airplane safety. And so I've been waiting now for someone to say, wait, climate is mission critical to your business. I won't disclose what the industry is, but you could probably guess it. And so, I think you're right. That's the proxy. And now they're going to the, for the jugular in this one.
I should point out, we've talked a lot about SEC rules and disclosure, but Betty's pointed us to the Delaware cases that have highlighted some of the board obligations with respect to oversight in this area. Those cases continue, by the way, to push forward on a number of fronts. So I think you're absolutely right that we're going to continue to see a backlash to the backlash, if you like, coming from plaintiffs who want the Delaware courts to weigh in on those obligations. I want to be sure we get to questions from the audience, but before I do, I think I'd be remiss not to ask this question. And Dahlia, let me start with you. The SEC's got a proposal out there. They've gotten like a few 100,000 comment letters. Many supportive, many angry, almost none like, well, that's about right. So my question for you, Dahlia, is tell us about BlackRock's perspective on the proposal. And for these purposes, I think I should give the audience a sense of what the proposal's made of. It's got basically three parts. The first is a descriptive analysis of the board's oversight and risk related to climate. Sort of like a management discussion and analysis, if you like, having to do with climate-related risk. Then it's got a disclosure that's borrowed from the Greenhouse Gas Protocol, requiring disclosure under certain circumstances of scopes 1, 2, and 3 greenhouse gas. We can talk more about that in a moment. And then finally, there's a disclosure, a modification of what's known as Regulation SX, requiring detailed financial disclosure. Here, this would be costs and other investments related to climate risks and compliance. This has also been a subject of some controversy. So, Dahlia, tell us a little bit about BlackRock's view. Do you think all those things should be adopted as proposed tomorrow, or you're not so sure?
So, Rob, I'd actually start by saying there are actually two other pieces to the SEC's work here, which is the fund disclosure rule and the fund naming rule. So this is a very large package of proposals from public issuers to investment managers and investment companies. I think, so, largely BlackRock, we have been very supportive of the SEC's efforts in this space. We've been supportive of regulatory efforts across the international ecosystem to bring, a globally comparable and consistent climate risks and climate disclosures so that investors like BlackRock can assess the risks and opportunities, and so that our clients can make informed choices, right? This is why this information is very important to BlackRock and other investors in this space. With that in mind, looking at the SEC's proposal, and appreciate this is, look, we're having this conversation because this is not an easy space, right? And this was a proposal, done after Allison, as acting chair, she put out the request for information. So even had that piece to help out. Very complicated space. There are 4 pieces that we think can really help the commission move forward here. First, there are parts of this proposal that steered away from the traditional concept of materiality, which, as you all know, we were sitting, me virtual, you in actual physical presence at NYU Law. materiality is just the cornerstone for U.S. securities disclosure, and it's worked really well for our markets. By way of one example, the 1% threshold for the financial statements, that was hard for us to see how that would be material. The second piece is climate risk disclosure has depended on the TCFD framework, and so many of the largest global companies in the world have adopted that, and they are using that as a framework. So better alignment between the proposal and the TCFD would help move this forward. In some cases, the proposals went to way too prescriptive, granular level that is just kind of not necessary, and that would actually help with the cost question that Allison was addressing. If you can bring that down, it would really help. The third piece, which is really important, despite those three pieces I mentioned, Rob, this is really focused on the U.S. public market, and that is by virtue of how our securities laws, function here. So, we noted that, and we noted that this could encourage sale of assets to private companies. It could discourage private companies from going public, which is, as you know, is not good for the retail markets or the U.S. markets, because it would reduce choice and negatively impact capital formation. So, we're not really sure how to thread that needle, but something that we warned about. And finally, we have to keep in mind in the US, we were just talking about the Delaware courts, the liability in the United States. So, looking at the appropriate liability standards as we recommend, how to get this disclosure more ingrained into our markets to reflect the evolving nature of that disclosure is really important, which is why we recommended the Commission consider a new form for some of this disclosure so that we don't have to have this strict liability, which is, as you all know, is part and parcel of the US markets. Like, for example, for certain elements of the GHG emissions, we thought they would be, better suitable for this new form. So, largely supportive, but provided what we hope is a constructive roadmap for the Commission to move forward in this space.
I want to take questions from the audience, and we're running out of time. But first, before I do, let me allow Allison Lee, the architect of the proposal that's now before the Commission, to talk about, to respond a little bit to some of the concerns that BlackRock, and to be fair to Dahlia, others have raised about the breadth and scope of the SEC's disclosure proposal.
Absolutely. So all of those are points that were given a lot of thought, and I know the SEC is continuing to sift through and think about them, but I'll start with one, the point you made, Dahlia, about the TCFD alignment. It is aligned, of course, broadly with TCFD, because what the proposal calls for are the first three prongs of TCFD, which is risk, governance, and strategy. But I think perhaps Dahlia is referring to some of the more granular elements around probably mostly the strategy piece and the monitoring piece of that, because there are some much more granular requirements than just a broad discussion, like you likened it to the MD&A, where they can sort of have free rein to do narratives. I think the thinking there was, let's make sure that we get some similar and identical type of information so that investors can compare what boards are really doing in this space. Did we get it exactly right? We'll see. Perhaps pulling back on that piece might make some sense. On the question of the 1%, so there, what that's a reference to is what the rule proposes to do is have companies disaggregate the costs and the impacts associated with climate change if they exceed 1% of a line item. But remember what Shiva said, there can be as few as 6 line items on a financial statement. So think about a multi-billion-dollar corporation that gives you 6 data points. So the idea there was we should disaggregate so that people can really see that the current impact, we're not talking about future now, we're talking about the current impact on a company's financials. Is the 1% the exact right amount? Could we have gone with materiality? Maybe, but what that would show, so first of all, I will say this, there is case law that does say 1% can be quantitatively material. I know because I helped make that case law when I was at the SEC, but secondly, what I would say is what you will see if you get that data is trend lines. You're going to see, are they moving in the right direction? financially currently. So I think that's an important piece. Again, I don't think 1%, there's no potential magic around 1%. Could that be changed? Potentially. I don't know what they may do. So, and then finally on the liability piece, setting up an entire new form for companies to fill out didn't quite, to me, seem to be potentially more burdensome and more costly. And so, I do think it makes sense to address the liability issue, but I would not have addressed it by setting up a separate form that has different levels of liability associated with it. We put a safe harbor in there to deal with scope 3 emissions. And I think my time is out. This must be But
Someone must not like these comments. Yeah. Well, actually, let's broaden out now beyond the SEC rule. And Betty, you're the NYU law grad, so I'm going to ask you all the hard questions today. Let's broaden beyond the SEC rule and ask the broader question that I think Vivek and others are really asking, which is these problems we're talking about, environmental, social, oversight-related problems, Betty, they're social problems. And the fundamental claim I think that many would make who are skeptical of this would be that the social problems should be solved in a democracy by the government. And I'll do my best Milton Friedman imitation and say that fundamentally the purpose of a firm is to maximize its profits within the bounds of the law, pay its taxes, and allow the government to make these choices. And to push it a little further, in a democracy, we should be worried, especially at a place where we study the formation and development of laws in a democracy. We should be worried, Betty, when it's us elites who are making social policy decisions through boards of directors, rather than through the democratic process. And Betty, what's really happening here is we've just run out of patience with the Congress and others who are failing to solve pressing social problems, and we've decided to do it through corporations instead. What would you say, Betty, to someone who takes that skeptical view of this entire ESG enterprise and says, no, we shouldn't be doing this through corporations, but instead through the government in a democracy. And the fact that you've become impatient with the Congress makes you neither unique nor well-suited to force this kind of change through entities ill-suited to do it. Betty, what say you?
Well, Rob, I'll start with saying that I'm extremely flattered that you counted me amongst the elites with you. So let's start with that. The next thing I'll say is, listening to all of this and just thinking about my job and what I do, Shiva didn't use the word stakeholders, but I think he was getting there with employees, customers, and he said, dare I say, if I'm misquoting, I apologize, the earth. And I think about policy and government, and maybe their stakeholders, who they're responding to, is very different than who corporations are responding to. So you set this up, and I'm actually just kind of free associating right now. If you think about governments, and they think, or state governments, a local state government, they're trying to appeal to their voting base, their population, which is very different than I think the businesses that I advise. And so those businesses are looking at their customers and they're looking at their investors. And so if you look at it, that's the reason why this is so different. Looking at the US government and what they've proposed and what they've passed, meaning federal and state, but then also broadening it out as you've asked or you're doing. The European Union, I mentioned it before, it's very different. And they similarly suffer from the same problem. They've got like policy needs that they've implemented, directives and regulations that are very divorced from how they should be applied by businesses. And so I'm not sure if I answered your question or just amplified it, but I guess, I don't know, maybe it's hard, I guess.
Yeah, well, it's we ask hard questions here at NYU. Allison, let me ask you. What would you say to those who would say that what you're really doing is trying to accomplish important social goals? I mean, I think Vivek and others would say, I think the social goals are important. I just think in a democracy, they should be done, those changes should be decided by the elected representatives of the people and not a boardroom, which has limited accountability to the people they mean to govern. What would you say to that?
I would start by saying that the SEC, of course, doesn't have an ESG disclosure rule out there pending right now. They do have, as Dahlia noted, a rule that would propose how funds need to classify their approach to ESG, but the SEC has not weighed in and said, here are the social metrics, here are the things that you have to sort of disclose. So that's kind of point number one. But point number two, is a bit more of a macro point, and that is we cannot ignore corporate America when we're looking at and thinking about these issues. They are a massive player. They're, when you look at the list of the top maybe 100 revenue producers in the world, and you include corporations and countries, most of them are corporations. Most of them are larger than most of the countries in the world. So they are spending massive amounts of political money and capital on these issues. So they are not just some sort of separate entity out there that we're roping into a scheme. They are a central player in the space. And they're acting in many different ways, mostly responsibly. They're trying to gauge and think through how to deal with these issues, but they won't go away. They're not going to leave the boardroom just because the SEC or others decide not to do these kinds of issues. They're going to be faced with these issues no matter what. They're having to make tough calls. So.
Makes lots of sense. Now, you've heard from us, but this wouldn't be an NYU Forum if we didn't hear from you. So you've heard a lot from us today. Please share your questions with this extraordinary panel. Please.
Spit it out?
Sure.
Okay. Number one, the new SEC rule, do you think it will be accepted by the federal courts or the Supreme Court? And two, are there any insights? I know this is the law school, insights from political science and like behavioral economics. We talk about why the electorate keeps on electing representatives which are against ESG. Is there any way of integrating that research to this? Because the people are voting for the electorate, even though they are being heard by climate crisis more.
Now, that's a great question, but if any of you can explain the behavior of the American electorate, we'd have to have a whole other session. So let's begin with your first question, which I think is a crucial one. And we've talked a lot about this SEC rule, but Allison, I got to start with you. Are the federal courts going to uphold this rule? Let's just agree, both of us having been on the SEC and you too, Dahlia, having served there, the probability of a lawsuit is 100%. Because regulation's expensive and lawsuits are less so, and there's no reason for entities so inclined to spin the wheel in the Fifth or the DC Circuit and see how they do. Allison, what do you think? Is this rule likely to survive the scrutiny that the federal courts will apply?
Well, I think the question is it likely to survive the scrutiny of the Supreme Court? Because I think it almost certainly is going to go there. So what happens at the circuit level? I bet it gets challenged in the Fifth Circuit, where they think they have the best, chance there. And to me, and I'm not a constitutional scholar. Rob, you could probably answer this question better than I, but certainly the major questions doctrine, which is relatively new, poses the largest threat to that rule because it's an unknown. There's not decades of precedent about what that doctrine really means, and it's quite malleable and can mean anything they want it to mean, so it can fit the agendas should they choose to do it that way. So my view is, yeah, there's a significant chance that some or all of the rule might be struck down by a Supreme Court that was so inclined, but it's not. There's no good way to gauge it, and it does not make sense to me for the SEC to do something different than what it thinks is right for the markets to try to sort of armchair quarterback that which I think is relatively unknowable.
That all sounds just right. And just to add one more perspective, I think Betty's really made a crucial point, which is that the market's moving this way anyway. Yeah. Now, we need a rule for the reasons Allison, Dahlia, and others have given, because we want comparability. We're worried about a selection effect that the firms that should most disclose will not disclose in a voluntary regime. Good standard arguments for transparency. But the existence of the SEC rule itself might nudge people toward where the market is going anyway, even if the Supreme Court eventually decides to strike it down.
Yeah, they have to comply until this happens. So how long is it going to take? 7 years? I mean, look at the West Virginia versus EPA case. Didn't matter.
No, the federal courts are very speedy. I think we had another question toward yes, please.
Yeah, sorry. I apologize if I misunderstood about the rule and what Allison said, but there's no prescriptive from the SEC on what ESG data actually should do. So there's no standardization of the data, just disclosures of which metrics are being used. And I guess the question I have is, does this not essentially offload the normative determinations of what ESG is to the third-party providers, which are, so in ways it's combining the worst of both worlds. It's neither a publicly made norm, so it's also kind of poses a question as to whether those are even the right providers, because they're often just creating these metrics based on the data that they already have that they've collected for other purposes.
It's a wonderful question. Let me repeat it for those who might not have heard it. The question is, Allison, by sort of just providing a disclosure rule, aren't we really offloading, and not specifying metrics with the exception of the GHG protocol, aren't we really offloading the way to think about ESG, climate, and social and governance matters to third-party index providers who have all the problems that we associate with the anti-democratic concerns that we have with firms doing this work in the first place? They're not especially accountable. They're owned by a very few data providers, number one. And number two, the evidence we have is that the data are quite noisy. There's inconsistency, there's imprecision in measurement. So, Allison, should we be concerned about those third-party providers?
Well, yes, but I want to be clear about what we're talking about. So at this point, the notion of the SEC isn't weighing in to say what metrics you need to look at and consider. That is a separate rule from the climate rule that we've been talking about. That is a rule proposal that would address how asset managers and advisors and the like are dealing with and selling these ESG products into the market. What the SEC did not do in that rule is say, here is what you must do in order to call your fund green or to call your fund an ESG fund, or here are the metrics that go into that calculation. And in part, that's because that is not within our remit. It's different. There's a taxonomy in the EU. They have a different remit. At the SEC, we're disclosure-based. So our view is, or has been, the view at the SEC has been, we took the world in that proposal, and Dahlia pointed out, and I have to say I'm inclined to agree with her on this last piece, but what we did was we took the rule and we divided the world into sort of three approaches that we observed were already happening as to how funds were thinking about and integrating ESG. We had ESG focused, ESG impact, and then we had something called ESG integration, which arguably takes up the entire universe, which I think was Dahlia's point, and I think there's something to that. But again, SEC is a disclosure-based agency, so we don't, for the most part, there are exceptions to that, but for the most part, our point is, whatever it is that you're using, whatever it is that you do, you need to be transparent about it, and that way we can enforce some accountability around what you've said you're doing, rather than define the landscape, which again, I think is outside the remit of the SEC.
Now, Dahlia, you and BlackRock have expressed some skepticism about this rule, and I'm wondering if you could share with us, does this put too much weight on third-party data providers? Is there some risk that will end up in a place where we're not measuring what we should be measuring or what investors think we're measuring when they invest in ESG funds?
So, how Allison phrased it is really well put, right? The SEC at its heart, and the rulemaking that the SEC does at its heart, it's about disclosure, right? And by the way, this is what's interesting about this entire space, because as investors in the market, what BlackRock and other investors have been asking for is disclosure. So that we can better assess risks and opportunities. So when you're looking at the SEC rules and looking at them from that lens, I shared with you some areas of concern that can help narrow the rule and get it to the right place. But ultimately, what you're looking for is more disclosure so that you're able to look at that data, pull it in as an investor, be able to make better calls about the risks, the opportunities, and share with your clients the data, the research, the analytics, so they can make an informed choice. So that data, yes, it will go to index providers. Yes, but it will also come to investors. It will also go to third-party data aggregators. We all know about these. This is why the SEC rules increasingly is looking at tagging the information, right? Allison and Rob, you both were huge proponents of data tagging. Why? Because it allows those third parties to take those voluminous disclosures and pull the information together and turn it into something readable by market participants. So you have to think about that there is a lot of audience for this information, including investors, including index providers, including other data aggregators. And all of that is actually really good for the US capital markets. No part of that is, in my opinion, in any way negative, because that is what makes our capital markets, frankly, the most robust in the world.
Dahlia, let me stick with you. We've got more questions in the room, but we've also gotten questions online. And one of our graduates asked the following question. I think he's posing it right to you, Dahlia. How do investment managers like you thread the needle between honoring ESG pledges to investors who want to see that work done and to whom you've promised you'll help do it, while also accommodating investors who are anti-ESG? How do you think about that, Dahlia?
So I go back to the foundation. Asset managers, not a single penny that an asset manager has is the asset manager's money. Not one. And Betty, you were talking earlier about what banks are doing. That has nothing to do with asset managers because we don't do balance sheet, right? So you have clients who are interested in sustainability, transition finance related portfolios that have made commitments, perhaps with their assets. And this is how an asset manager like BlackRock, we will manage their assets in accordance with their mandates to get the best risk adjusted returns for them. We also have clients that have, a different take on this. They are not interested perhaps in climate related, information in their portfolios. That is their mandate. And we manage in accordance with their choice and their mandate. That is what a fiduciary asset manager is. You have to you work in the best interest of your client within the scope of that relationship, which means within the mandate of that relationship and your client's time horizons and risk mandates and all that good stuff that I know you know. So the client choice is so fundamental to what an asset manager does. And that is what enables asset managers to service different types of clients with different types of mandates.
Other questions? Yes, please.
Hi, so a lot of ESG funds, including several managed by BlackRock, have substantial investments in the private prison industry. And so I was wondering, to the extent that ESG is labeled into one moniker, if the E, the environmental component, is being used as sort of like a greenwashing element to sort of surpass and sort of lay this sort of pretty picture over substantial investments into, and then political contributions into other industries that actually have like substantial pernicious effects on the society that we live in.
Awesome. So, Dahlia, here's the question. A student wants to know, many ESG classified funds are investing in industries that are arguably have negative externalities, to borrow Shiva's phrase, on society. For example, the private prison industry. And isn't there some risk that all these ESG funds is greenwashing? Telling people that we're doing better investing that's better for society, when in fact all we're doing is the same old thing and maybe taking an extra fee. So Dahlia, why are you doing that?
That's a great question. So first of all, on greenwashing and coming back to one of the key proposals the SEC put out, the fund disclosure, that was one of the fundamental premises behind that rulemaking, which we are very supportive, because it's really, really important for investors to understand what they're investing in, the objectives of the fund, how the fund is performing, et cetera. So, that is something regulators across the globe are looking at. There is also, but this comes back to a fundamental misunderstanding of what ESG is about. And frankly, the fact that we are still using ESG, which has three very different things put together. And so that it creates, frankly, a lack of understanding about what the investment actually is, right? So you can have an ESG fund that screens, and it would screen out sin stocks or other types of stocks, fossil fuels, prisons, or other stuff. That's a screened investment that reflects a value of the investor. You can also have ESG funds that are sustainable funds, and those are, for example, they would be a Paris-aligned fund. Can you start seeing the differences as I go down the examples of how just using this moniker can not provide them, the investor, with the information they need, and why we need to get to a better place in terms of explaining what is sustainable, what is climate related, how these things come together, and how they're part of capital markets.
Now, Dahlia, just to push you, and I'm sorry to interrupt, but just to push you, I think that was the purpose of the SEC rule. Does BlackRock support adoption of that rule as written?
Which rule, Rob? Because there are three of them.
Well, I can turn to Allison. She can give some background on the motivation for some of those proposals. And I'd love to hear more, because I think what the student's question is getting to is, wouldn't it be helpful to have more transparency about what it means to be in an ESG fund? And Allison, I think the SEC's proposals are trying to move in that direction.
They are, and they're trying to address that. That's central to what the SEC is trying to do, is to address the greenwashing issue with the two fund rules, setting aside the climate disclosure rule, which will, of course, I think, also help address greenwashing. But the fund rules are two. There's one, which is a naming rule, which changes the conventions around how funds can use names and what they have to do if they're going to call their fund green, or if they're going to call it sustainable and the like. How much of their investments need to be focused on that, because many investors will hardly look past the name of a fund. So there's the fund naming rule, and then there's the ESG disclosure rule, which is targeted almost entirely around trying to address greenwashing. And the point there is what I said earlier, which is, tell us what you mean when you say you're going to do X, Y, or Z, whatever it is, if it's E, if it's S, if it's G, and then say what you mean and mean what you say, so that we can bring some accountability to the folks that are selling these funds.
Shiva, let's turn to you. I mean, I know you've written about this. Tell us, what is this concern, this greenwashing concern among investment funds, a real one, and what should we do about it?
Oh, it's absolutely real. But I want to make a bigger point. This labeling issue goes beyond ESG. So if you look at value funds or growth funds or quality funds, can someone tell me what quality means? And why don't you use the word greenwashing in that context? A value fund will have a growth fund. I don't even know what they mean by value. Is it market to book? Is it price to earnings? Is it what? Except we don't have any problem with that. In fact, the whole labeling issue, I think, is a deeper point. And I'm so happy that we're having a conversation about labeling, about the other funds as well. But ESG is the excuse to have that conversation. So labeling is, I can go on and on, Rob. Eggs.
Well, Dahlia, let me turn back to you. So those two rules, the naming rule and the ESG-related rule, these transparency rules around making sure funds have to tell investors what they mean by these things. Does BlackRock support those rules?
So, Rob, yes, we largely support the SEC's efforts in the space, but I will come back to it that what the SEC did is still sort of double down on this integrated ESG. The ESG integration, for example, even stewardship, which, by the way, stewardship, 90% of that has nothing to do with climate or social or anything. It's governance. It's good governance. ESG, the G is governance, something that is fundamental to corporate America. And yet when people talk about it, and you just had a discussion about it earlier, people think there's some social or political or ideological concept behind the moniker. So, and Shiva's point, I completely take that as well. I mean, there is a wider issue. I mean, the naming rule in general, I've never been a fan of that rule. So that's just me personally speaking, because I think sort of it's a lot to put into just a name of what it can give to an investor, and an over-reliance on that can be an issue. But you have a much more fundamental issue here, which is that environmental, social, and governance are three concepts that have a lot to them. And the funds that can have ESG strategies have a lot of variety. And if you just lump it under just that one moniker, are you giving the market the information they need? Or do we need much more nuance to how we approach these strategies? I put that question to you.
Thank you so much, Dahlia. And folks, these are the kinds of hard questions that we ask here at the Latham & Watkins NYU Law School of Law Forum. I'm very proud to have hosted this conversation and pursued those hard questions. We don't purport to have all the answers, but we're looking forward as a group, and I think as a society, to the SEC's and other regulators' work in moving us forward on these crucial questions. Please join me in thanking our panelists for this exceptionally thoughtful conversation. And thank you all for joining us. Thanks again.